Mr. Chairman, these allegations, either individually or collectively, are basically suggestions by the most senior parts of the establishment that their Commissioner of Police, their Assistant Commissioner of Police, and their Superintendent officers may have suppressed evidence and given to this inquiry, on oath, incorrect information. They border, let's be frank, at suggestions of unlawful behaviour, a suggestion that the RGP or certain officers may have breached Section 27 of the Inquiries Act, which makes suppression of evidence or preventing evidence reached in the inquiry an offence. Mr. Chairman, I am instructed to make it clear that if that's really the complaint from the government parties, and that was what your conclusion was, then the RGP and its senior officers would understand and indeed welcome that they and all court participants should put all of their information and devices to forensic analysis. Moreover, any party that you deem to have failed should, without good reason, or to use the words of the statute, in essence, reasonable excuse, face the full force of the law. After all, it's been the RGP's position that no one should be above the law. The rule of law must survive this sorry episode in Gibraltar's history. Now, that is not to say, and I make this point, that the RGP could not have done things better on disclosure. They will accept criticism. But that's a far cry from what's being implied here. The RGP position is that most WhatsApps in question that we have seen since June are not largely, save a few, relevant or would be considered to be work-related. Firstly, they require hindsight, i.e. looking at these WhatsApps through today's prism of relevance in the context of a public inquiry. Secondly, most, if not all, WhatsApps do not include policing obligations, keeping the peace, security, investigating, detecting crime, and prosecuting crime. Thirdly, the RGP reiterates what it's already said. It doesn't do its business on WhatsApp.